Did you know that there's no constitutional right to an abortion in the United States? That's what it says in the leaked draft opinion from the United States Supreme Court on an abortion case that is pending before the Supreme Court. So I'm going to walk you through that decision, how the case got to the Supreme Court, what it's all about, and what the potential outcome is. So, hi there. I'm Michele Hagan. I'm a legal analyst and a former prosecutor. You may recognize me because I provided a lot of legal analysis on the Elizabeth Holmes case. This video is simply my opinion. It's for education and informational purposes. And I understand that the subject matter is very sensitive, but I'm just putting on my lawyer hat here and just giving you my analysis. And it's a rare opportunity that we have to see a draft opinion from the Supreme Court. And Justice Roberts, the Chief Justice Roberts, has said that this draft opinion is authentic. However, it's just a draft. It's not their final opinion. And he has said that the leak of this opinion is an egregious breach of trust, and he has ordered an investigation as to the source of this leak. So we're going to go through this opinion, but before I get there, a couple things first. One, we have our next live stream, which is on Thursday, May 5th, from 12:15 to 1:15 Pacific Daylight Time, California time. So please join me. I'll do an update on the Sunny Balwani case, as well as possibly talking about this topic. So please do leave your suggestions. And again, this is just my analysis, so please leave a comment. Please support my work by subscribing. And by the way, several of you have reached out and asked how you can support my work. So I'm going to put a link for a donation in the description if you'd like to donate. Thank you very much. I appreciate that. So, let me give you a little background about the abortion law in the United States. And this is for everybody. You know, I have viewers from outside the United States. So currently in the United States, there was a Supreme Court case called Roe versus Wade in 1973, which recognized the constitutional right to an abortion. However, as this opinion points out that we're going to look at, the Constitution does not even mention abortion, and it doesn't recognize the constitutional right to an abortion. But because the justices, the Supreme Court in the Roe v. Wade case, decided that it's an implicit right to have an abortion, and it comes under the right to privacy and several of the constitutional rights, the First Amendment, the Fourth, the Fifth, and I'll show you that in this decision. And then in 1992, there was a case called Casey. I think it's Planned Parenthood versus Casey that came out that further recognized the right to an abortion, but limited it to, I have to double check my notes here, to no abortions after 24 weeks. In Roe versus Wade, it was no abortions after the first trimester. The case that's up on review by the Supreme Court, which is the subject matter of this decision, this draft decision that we're going to take a look at, that case is based on a law that was passed in 2018 in Mississippi. It's a state law. It's called the Gestational Age Act. And the legislature in Mississippi passed this law that prohibited abortions past 15 weeks. Okay, so then it was challenged. The law was challenged. The lawsuit was filed by the Women's Health Organization, which is saying that basically this Mississippi law, this Gestational Age Act law, is basically doing away, overturning Roe versus Wade and Casey, because it's further limiting the right to an abortion that was recognized in Roe versus Wade. I hope this is making sense. Okay, so we'll flush it out as we go through this draft opinion. And this is fascinating to me as a lawyer to be able to get a sneak peek it's also going to be very interesting how the court's going to rule now that this draft opinion is out there. So there's, just to give you the quick movie trailer, so to speak, or head notes or cliff notes rather, the court says in this opinion that because the Constitution doesn't recognize the right to an abortion, it's not in the Constitution. The other reason they say is that it's not rooted in our history, the right to an abortion, and that thirdly, that the prior cases were wrongly decided, meaning Roe versus Wade and Casey. The reasoning in the decision was wrongly decided according to this draft opinion. So I'm going to go through this with you. So hang in there. It's quite an education going through this this draft opinion. Okay, so let's take a look at the opinion. And I'm just going to point out, I'm going to go through, I'll share all of it with you, but I'm only going to go through parts that I think are going to be helpful to explain to you. So let's go through it. So it's a draft opinion written by Justice Alito. That's Justice Alito up here. He's the one who's writing the opinion. And it was circulated February 10th, 2022, around to all the other justices, right, to disagree or to review this opinion, to make any changes. And it says right here, it's the first draft. And it says here, the opinion, let me enlarge it here. The opinion is subject to formal revision before publication. So what they do is the Chief Justice assigns an opinion to one of the justices to write it up, and then it's circulated among the other justices to make suggestions to the draft, okay? So it's called the Dobbs case, and that's after Thomas Dobbs, who was the state health officer in Mississippi. So the Jackson Women's Health Organization, Jackson, Mississippi, Jackson's Women's Health Organization sued the state health officer because they're claiming this law is unconstitutional, this Gestational Age Act, okay? Came out of the Fifth Circuit Court of Appeal, and here's the draft opinion. It's pretty amazing. So you can go ahead and read this. It gives a little background on abortion. Talks about the first 185 years after the adoption of the Constitution. Each state was permitted to address this issue in accordance with the views of its citizens. And then in 1973, Roe versus Wade was decided, where the court recognized a right to an abortion, okay? This decision, the outcome of this decision is to overturn Roe versus Wade and to let the people decide, That means every state will decide what their law, potentially, if this is what the Supreme Court decides, which the Constitution says is the law of the land, it'll give each state its opportunity, each voters, all the citizens, to determine what is their law regarding abortion in their state, okay? So then you can go ahead and read this. I'm just going to scroll through it. Hopefully I'll go slow enough so you can read it. This is all just giving the background of the prior cases. And again, this court and this decision is basically saying that those cases were decided wrongly. Therefore, we don't have to rely upon them. It's called stare decisis, meaning relying on prior cases. Okay? So right here it says, before us now is one such state law. The state of Mississippi asks us to uphold the constitutionality of a law that generally prohibits an abortion after the 15th week of pregnancy, several weeks before the point at which a fetus is now regarded as viable outside the womb. In defending this law, the state's primary argument is that we should reconsider and overrule Roe versus Wade in the Casey decision, and once again allow each state to regulate abortion at its citizens' wish. And that's basically what the court decides in this draft opinion. On the other side, the respondents and the Solicitor General ask us to reaffirm. This is the Jackson Women's Health Organization is asking the Supreme Court to reaffirm Roe and Casey, and they contend that the Mississippi law cannot stand if we do so. allowing Mississippi to prohibit abortions after 15 weeks of pregnancy, they argue, would be no different than overruling Casey and Roe entirely. They contend that no half measures are available and that we must either reaffirm or overrule Roe versus Wade. And in this decision, they decide to, it says it right here, we hold, in other words, we decide, we hold that Roe and Casey must be overturned. The Constitution makes no reference to abortion. You can look at the U.S. Constitution. The word abortion does not appear. And no such right is implicitly protected, meaning they can't imply it through the First Amendment, the Second Amendment, the Fifth, right? It's not implicitly protected by any constitutional provision. So they're throwing out the reasoning in Roe versus Wade, where those Supreme Court justices back in 1973 said that the U.S. Constitution implicitly gives a right to an abortion under the First Amendment, right to privacy, the Fifth Amendment, I think the Fourth Amendment, due process, and equal protection, 14th Amendment. We hold that Roe and Casey must be overturned. The Constitution makes no reference to abortion. It's not implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey chiefly rely upon, the due process of the 14th Amendment. That provision has been held to guarantee some rights that are not mentioned in the Constitution, but any such right must be deeply rooted in the nation's history and tradition. So this Supreme Court, the current Supreme Court, is saying because abortion is not recognized as a right in our history, in the United States history, in the nation's history and tradition, and it's not implicit in the concept of ordered liberty, therefore we're not going to recognize it, is basically what they're saying. The right to an abortion does not fall within this category. Until the latter part of the 20th century, such right was entirely unknown in American law. Indeed, when the 14th Amendment was adopted, the Due Process Amendment, 3/4 of the states made abortion a crime at all stages of pregnancy. Therefore, I think what the Supreme Court is saying here, and again, this is just my opinion, is because it was against the law by 3/4 of the states, how could they recognize, how could they say that it was rooted, abortion, the right to an abortion is rooted within our history, is what they're, I think, saying here. The abortion right is also critically different from any other right that this court has held to fall within the 14th Amendment's protection of liberty. They're not even recognizing in this decision that abortion is a right to liberty, a liberty right. Roe defenders characterize the abortion right as similar to the rights recognized in past decisions involving matters such as intimate sexual relations, contraception in marriage, but abortion is fundamentally different according to this Supreme Court, because it destroys what those decisions called fetal life and what the law now before us describes as an unborn human being. And then they talk about stare decisis, which is when the court has the opportunity to rely on prior decisions, such as the Roe decision and Casey decision. In this decision, our current Supreme Court is distinguishing from Roe versus Casey and saying we don't have to abide by prior decisions because those decisions were wrongly decided. Okay? And they say here it does not compel an unending adherence to Roe's abuse of judicial authority. This court is saying that the Roe decision was an abuse of judicial authority. For the court, the Roe court, the Supreme Court in the Roe versus Wade decision, to make that decision was an abuse of judicial authority. Roe was egregiously wrong from the start. Egregiously wrong from the start. Its reasoning was exceptionally weak, and the decision has had damaging consequences. And far from bringing about a national settlement of the abortion issue, Roe and Casey have inflamed debate and deepened division. This court has determined that the Roe decision and the Casey decision recognizing a woman's right to an abortion has inflamed debate and deepened division in the United States. That's what they're saying here. It is time to heed the Constitution. In other words, to follow the Constitution, I think is what they're saying, and return the issue of abortion to the people's elected representative. The Constitution does start with, and I'll say right here, we the people of the United States. I think that's what the Supreme Court is relying upon here. It is time to heed the Constitution and return the issue of abortion to the people's elected representatives. The permissibility of abortion and its limitation upon it are to be resolved, like most important questions in our democracy, by the citizens trying to persuade one another and then voting. So right here they're saying, let the people decide regarding the abortion issue. Okay? So you can go ahead and read this. This talks about the Gestational Act. Okay, and then they talk about who the respondents are. It's an abortion clinic called the Jackson Women's Health Organization. On the day the Gestational Age Act was enacted, they filed, this is how it got to the Supreme Court. They filed this lawsuit in the federal district court because they're challenging a constitutional decision, Roe versus Wade, the Supreme Court decision which relied on the Constitution. So that goes to federal court. And they sued the Mississippi officials, alleging that the act violated the constitutional right to an abortion. The district court granted a summary judgment in favor of the respondents, the doctors who brought this lawsuit, or the health organization that brought the lawsuit, and they permanently enjoined the enforcement of the act. In other words, they permanently stopped Mississippi from applying this law. Okay? You can go ahead and read that. And then it was appealed by the Mississippi state officials to the U.S. Supreme Court. In the Supreme Court, they went to the Fifth Circuit of Appeal. It was affirmed at the Fifth Circuit of Appeal. Therefore, the Mississippi officials, the ones who wanted to uphold this Gestational Act prohibiting abortions past 15 weeks, they appealed to the Supreme Court, the U.S. Supreme Court, because that's the final law of the land, the supreme law of the land in our Constitution. So it went from district court to the Fifth Circuit Appellate Court to the U.S. Supreme Court to decide this constitutional issue. We granted certiorari to resolve the question whether all pre-viability prohibitions on elective abortions are unconstitutional. In other words, because Casey was the 26 weeks was the current law, no abortions past 26 weeks. This Mississippi law was no abortions past 15, and the viability is viability is sometime after 15 weeks, is what the Women's Health Organization argued. So the U.S. Supreme Court is deciding whether or not all pre-viability, anything after, anything before the viability of the fetus, whether or not that's unconstitutional. So whether or not Mississippi could set this 15-week limit, whether or not that violates the Constitution, okay? And so you can go ahead and read this. They say that Roe and Casey were wrongly decided, and the act is constitutional because it satisfies the rational basis review. The rational basis review is the standard test that the Supreme Court has to apply because whenever it's challenging a constitutional issue, such as the right to abortion, it's strict scrutiny. It has to be a higher standard of review. But what the Mississippi officials are arguing here is that it's it's a lower standard of review. It's a rational basis standard of review because it's not a constitutional right to have an abortion. Okay, is what the Mississippi officials are arguing to uphold their Gestational Age Act. Okay, so you can go ahead and read this. They are giving us, explaining the law, the 14th Amendment, prior case law. And they talk about Roe, however, was remarkably loose in its treatment of the constitutional text. See, in this decision, the Supreme Court is having to distinguish itself and explain why they're not going to have to rely on Roe, right? So they're saying it was remarkably loose. It held that the abortion right, which is not mentioned in the Constitution, is part of a right to privacy, which is also not mentioned in the Constitution. And that privacy right in the Roe decision had been found to spring from no fewer than 5 different constitutional provisions: First Amendment, the Fourth Amendment, the Fifth Amendment, the Ninth Amendment, and the 14th Amendment. Okay? So here's where they're explaining their reasoning. They're saying we don't need to follow the prior precedent of Roe. We can distinguish this case from Roe. In fact, we're going to say that Roe was wrongly decided because it basically, made up a right to privacy, I think is what they're trying to say here. And that, it was relying on all these constitutional provisions, and abortion isn't a constitutional right, is what they're saying here. So they're laying out their reasoning as to why they come up with their decision to let the people decide, right? To let the people decide whether or not there's a right to abortion in each one of the states, is basically what they're saying. So you can go ahead and read this. And they talk about the Casey case. So now they need to distinguish from the Casey case and why the Casey case does not apply. The Casey court did not defend their unfocused analysis. They're saying the court was unfocused analysis and instead grounded its decision solely on a theory that the right to obtain an abortion is part of the liberty protected by the 14th Due Process Clause. So again, they're saying that Casey was wrong too. It had unfocused analysis. It was based on a theory of liberty. Okay, and you can go ahead and read this. And they also talked about how the 14th Amendment Equal Protection Clause doesn't apply either. So again, the Supreme Court, in their decision here, their draft decision, it's not final, they are explaining to us why they are not following the prior cases, which is usually what a court does. They look to see what the prior rulings are. In this case, it would be the Roe case and the Casey case. But this Supreme Court is saying, no, we're not going to follow that. We don't have, it's not strictly, we don't have to strictly adhere to prior decisions, especially ones that were wrongly decided, according to their opinion. Okay? So, but our decisions have held that due process clauses protect 2 categories of substantive rights. And they talk about, whether it's a fundamental right, if it's not mentioned anywhere in the Constitution, which abortion isn't. In deciding whether a right falls into either of these categories, the court has long asked whether the right is deeply rooted in the history and tradition. So here's the second prong. Number 1, it's not in the Constitution. Number 2, it's not deeply rooted in our history or tradition. And then long discussion here about prior cases. You can go ahead and read that. Historical inquiries of this nature, whether it's rooted in our history, are essential whenever we are asked to recognize a new component of the liberty protected by the Due Process Clause. In other words, to recognize a new liberty, we have to look at our history. That is why our court has long been reluctant to recognize rights that are not mentioned in the Constitution because of abuses, right? So go ahead and read this. On occasion, when the court has ignored the appropriate limits imposed by respect for the teaching of histories, it has fallen into the freewheeling judicial policymaking that's characterized discredited decisions. So when they're freewheeling, they end up making decisions that later get discredited, I think is what they're saying. Instead, guided by the history and the tradition that map the essential components of our nation's concept of ordered liberty by looking at our traditions and our history, we must ask what the 14th Amendment means by the term of liberty. When we engage in that inquiry in the present case, the clear answer is that the 14th Amendment does not protect the right to an abortion. So in other words, this court, our current Supreme Court, doesn't see liberty, doesn't define liberty to include the right to an abortion. And you can go ahead and read these. Footnotes are always interesting to read. And then it talks about, the history until the 20th century. There was no support in American law for the constitutional right to have an abortion. Zero, none. No constitutional provisions had recognized that right, etc. And then again, they talk about by the time the 14th Amendment came around, 3/4 of the state had made abortion a crime. So clearly, they couldn't have meant to have the 14th Amendment include the right to an abortion if 3/4 of the state considered it a crime. And they talk about Roe either ignored or misstated this history, and Casey declined to reconsider Roe's faulty historical analysis. It's therefore important to set the record straight. This Supreme Court wants to set the record straight on those prior two decisions. They didn't follow history, therefore we're not going to follow it, I think is what they're saying here. And you can go ahead and read through this. I'm just going to scroll through it because, I want to know what your analysis is too. So I'm going to present to you the whole decision, all right? So you can scroll through this at your leisure. I think it's fascinating stuff as a lawyer, but maybe I'm just a geek. So in sum, although common law authorities differed on severity of punishment, no one endorsed the practice of abortion. Moreover, we are aware of no common law case or authority, and the parties have not pointed to any that remotely suggest a positive right to procure an abortion at any stage of pregnancy. So again, they're laying out their reasoning as to why they're concluding this. They're looking at the historical record. Just going to scroll through this here. There's a lot in here where they're, really trying to explain what the prior cases were. In this country during the 19th century, the vast majority of states enacted states criminalizing abortion at all stages of pregnancy. Again, restating their reasoning. This overwhelming consensus endured until the day Roe was decided. At that time, also by the Rose Court own count, a substantial majority, 30 states, still prohibited abortion at all stages, except in the life of the mother. In short, the court's opinion in Roe itself convincingly refutes the notion that the abortion liberty is deeply rooted in the history and tradition of our people. So they're relying on Roe here to say that, Roe even points out that our history doesn't support a right to an abortion. Okay. It's not deeply rooted in our history. There's no persuasive answer to this historical evidence. Instead, respondents are forced to argue that it doesn't matter that some states prohibited abortion at the time that Roe was decided or that the 14th Amendment was adopted. And there's no support in the existence for an abortion right. Again, the court is restating its reasoning here. Okay. So you can go ahead and scroll through this. And by the way, the live stream is Thursday, if I forgot to mention it, 12:15 to 1:15 California time. I think I did mention it, but anyway. And then they talked about Roe terming this a right to privacy, the right to an abortion, in Casey describing it as a freedom to make intimate and personal choices. And then they talk about it at the heart of liberty is the right to define one's own concept of existence, of meaning, or of the universe, and of the mystery of human life. That's what they said in Casey. This court is not relying on that. Ordered liberty sets limits and defines the boundary between competing interests. Roe and Casey each struck a particular balance between the interest of a woman who wanted an abortion and the interest of what they termed potential life, drawing the balance between a woman's right to an abortion and the life of the fetus. Our nation's historical understanding of ordered liberty does not prevent the people's elected officials, elected representatives, from deciding how abortion should be regulated. So again, they're saying it's up to the people's elected representatives to decide how abortion should be regulated. Nor does the right to obtain an abortion have a sound basis in precedent. So again, they're restating all of these cases, and to me it's fascinating to look at all these cases and how, what these cases stand for. the right to make decisions about education on one's children, the right to contraceptive, the right to not be sterilized without consent, all of this. The right to certain circumstances not to undergo involuntary surgery, forced administration of drugs, or substantially similar procedures. Again, all the prior cases that were decided that this Supreme Court has reviewed. The right to marry a person of the same sex, etc., the right to engage in private consensual sexual acts, all of these these rights have been recognized in prior decisions by the Supreme Court. These attempts to justify abortion through appeals to a broader right to autonomy and to define one's concept existence proves too much. So they don't want to extend it to the right, they don't want to recognize the right of an abortion here, constitutional rights in abortion. What sharply distinguishes the abortion right from the rights recognized in the cases cited above, upon which Roe and Casey rely, is something that both these decisions acknowledged. Abortion destroys what those decisions call potential life, and what the law at issue in this case regards as the life of an unborn human being. None of the other decisions cited in Roe and Casey involve the critical moral question posed by abortion. They are therefore inopposite. They do not support the right to obtain an abortion, and by the same token, our conclusion that the Constitution does not confer such a right to an abortion does not undermine them in any way. So it doesn't undermine any of those prior decisions that the court has made on other rights, not the abortion rights, but on other rights, the right to marry same sex, the right to all those other prior cases that we looked at there. Okay, so you can go ahead and read this. A lot of it is restating, but I'm just highlighting certain areas here. They have failed to make the showing that they have failed to make the showing, and we must thus return the power to weigh those arguments to the people. So again, they want to return the decision on the abortion question to the people. It protects the interests of those who've taken action in reliance on past decisions. We have long recognized, however, that stare decisis is not an I can't even say that word. Anyway, they don't have to rely on prior cases, is basically saying. But when it comes to the interpretation of the Constitution, the great charter of our liberties, which was meant to endure through a long lapse of ages, they're relying on the Constitution here. It's not in the Constitution, therefore we don't have to recognize it, I think is what they're saying. In addition, when one of our constitutional decisions goes astray, which they're saying Roe versus Wade and Casey went astray, the country is usually stuck with the bad decision unless we correct our mistake. They're trying to set the record straight here. They're trying to correct their mistake in the prior decision. Therefore, in appropriate circumstances, we must be willing to reconsider and, if necessary, overrule constitutional decisions. So they are reconsidering the Roe decision, the Casey decision, and they want to overrule it. That's what this decision says. And some of our most important constitutional decisions, again, this is their reasoning, this is justifying why they're going, at this point, why they're deciding to overrule the Roe case and the Casey case. Because our most important constitutional decisions have overruled prior precedents. And they cite Brown versus Boyd of Education, Plessy versus Ferguson, etc. You can go ahead and read these. All cases I had to study when I was in law school. All right, so we're going to keep going through this. I hope this isn't getting too long here. Okay, so in this case, they talk about 5 factors weigh strongly in favor of overruling Roe and Casey: the nature of their error, the quality of the reasoning, and the workability of their rules. And then they go into the nature of the court errors. You can go ahead and read this. Roe was also egregiously wrong and deeply damaging. It's egregiously wrong on the day it was decided. It was on a collision course with the Constitution. You can go ahead and read this. To me, this is fascinating. and that it wrongly, this court, Supreme Court, current Supreme Court is saying it wrongly removed an issue from the people in the democratic process. Let the people decide. Let our democracy work. That's what they're saying here. Roe was incorrectly decided. It was plain wrong. It was based on weak grounds. You go ahead and read this. Okay. Then, by the way, do hit the like button and do subscribe to this channel. Please support my work. And if you want to donate to support my work, I greatly appreciate it. And I'll put a little link in the description. I'm just talking while we're scrolling through this. And please do let me know what your analysis is. What do you think of this? I mean, I think it's fascinating that we get a sneak peek into the decision, and we get an eye into how these Supreme Court justices think and how they reason. Okay. Um, but even and again, we haven't seen any dissenting opinion, right? Because this is just the draft. They haven't made their concurring opinions or their dissenting opinions. Those justices who may decide differently, who may reason differently, we haven't seen their opinions. This is just the first draft, okay, of the opinion by Justice Alito. Okay, and then you can go ahead and read through this. We've got about 15 more pages here, but I'm just going to scroll through so you can take a look at it. Please do join me for the live stream on Thursday, and please, leave a comment here or a question. Give me some suggestions for the live stream and questions for the live stream as well. So leave that in the comment. They said that the U.S. Supreme Court has 5 times had to look at the Roe and the Casey decision, and this is the first time that they're actually thinking about and writing that they're going to overrule it. They're going to overrule Casey and Roe if this opinion stands. Okay. It's an interesting question. Do we let the people decide or do we let the Supreme Court case law, make a decision? Do we let the people vote in each state, determine what rights they're going to give regarding abortion, whether they're going to permit it or not permit it? And they talk about 24-hour waiting period in Pennsylvania. These are all a lot of the prior cases. Okay, we're almost through this here. Let's see. I think I have some highlights coming up here. Okay, they're again distinguishing prior cases. Okay, our decision returns the issue of abortion to those legislative bodies, the people that we elect to represent us. And it allows women on both sides of the abortion issue to seek to affect the legislative process by influencing public opinion, lobbying legislators, voting and running for office. Women are not without electoral or political power. Our decision returns the issue of abortion to those legislative bodies and allows women on both sides of the abortion issue to seek to affect the legislative process by influencing public opinion, lobbying legislatures, voting and running for office. With all due respect to the Supreme Court, I think men also care about this issue. Okay? So by limiting to women, I don't know about that. Women are not without electoral or political power. It is noteworthy that the percentage of women who register to vote and cast ballots is consistently higher than the percentage of men who do so. I think men and women have an opinion on this issue. I don't think it's just a women's issue, with all due respect to the Supreme Court and Justice Alito. It's just my opinion here. In the last election in November 2020, women who make up around 51.5% of the population of Mississippi constituted 55.5% of the voters. Okay, so, it's the people decide or is it the women decide? What are they saying here? So, suggest that we overrule. Let's see. You can go ahead and read this. The American people's belief in the rule of law would be shaken if they lost respect for this court. as an institution that decides important cases based on the principle, not on social and political pressure. So they're saying their decision is not based on a social or political pressure. It's based on what the law says, the rule of law. That's what they're saying here. They're saying it's not a political decision. We're making a decision based on what the law says. The judicial branch deserves its legitimacy, not from following public opinion. They're not following public opinion, but from deciding by its best lights whether legislative enactments of the popular branches of government comport with the Constitution. In other words, let the legislative body, let the people decide what the law is. Okay, you can go ahead and read this, and we're almost on the last page here. Our sole authority is to exercise judgment, which is to say the authority to judge what the law means and how it should apply to the case at hand. That's what they're doing. They're simply setting the record straight. They're simply doing their job here. That's what they're saying. And the court has no authority to agree that an erroneous precedent is permanently exempt for reevaluation. In other words, their ability to overturn Roe and Casey. Neither decision, okay, indeed in this case, 26 states expressly ask us to overrule Roe and Casey and to return the issue of abortion to the people and their elected representatives. This court's inability to end debate on the issue should not be surprising. This court cannot bring about the permanent resolution of the I can't say that word either, national controversy simply by dictating a settlement and telling people to move on. Whatever influence the court may have on public attitudes must stem from the strength of our opinions, the respect of the court, the strength of their opinions based in, I think they're saying here, grounded in the law, not an attempt to exercise raw judicial power, which is what they say they did in the Roe court. We do not pretend to know how our political system or society will respond to today's decision overruling Roe and Casey. And even if we could foresee what will happen, we will have no authority to let that knowledge influence our decision. We can only do our job, which is to interpret the law, apply long-standing principles of stare decisis, and decide this case accordingly. We therefore hold that the Constitution does not confer a right to abortion. Roe and Casey must be overruled, and the authority to regulate abortion must be returned to the people and their elected representatives. And then they talk about the standard, which is the rational basis, not the higher strict scrutiny, because they don't recognize it as a constitutional right, which would make it a higher standard of review. Okay, and you can go ahead and read this. We end this opinion where we began. Abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Let the people decide, is what they're saying. Roe and Casey arrogated that authority. We now overrule those decisions and return that authority to the people and their elected officials. The judgment of the Fifth Circuit Court of Appeal is reversed and the case is remanded. It is so ordered. So there it is. There's their decision. There's our sneak peek into the draft decision, the draft opinion of the United States Supreme Court on whether or not there is a right to abortion, constitutional right to abortion in the United States. This decision, if it stands, it will overrule Roe versus Wade and the Casey decision, and the right to an abortion will be decided by each state, by the people of each state and their elected representatives. So what do you think? What do you think of this decision? I think it's fascinating, and I encourage you to spend the time to read it. It's quite an education. Okay, so thank you very much for staying with me, and please do subscribe to this channel. Please support my work by hitting that like button and by subscribing to this channel, and donate if you wish. I appreciate it. And please do join me for the live stream. And thanks again for watching.